Welcome to this Willwriters Association monthly video and email newsletter for the 1st of August 2015. This newsletter covers two key topics as well as a miscellany of other items. The first of those is the ruling of the 26th of July, where a woman has been awarded £164,000, one-third of her mother's estate, after being cut out of her mother's inheritance, which highlights the need for expert professional advice in such situations and gives you an opportunity to recheck your practices, as well as looking at what does this all mean for the future. And then secondly, the EU Succession Regulation number 650/2012, also known as Brussels 4, has been adopted across 25 of the 28 of the European Union countries and will come into force later this month on the 17th. So starting first of all with the case of Ilott versus the estate of Jackson. On the 25th of July 2015, a long-running inheritance case, Heather Ilott versus the estate of her mother, Melita Jackson, was ruled upon by the Court of Appeal in a manner which, if not further appealed, sets a new post in the ground as regards the potential entitlement of adult children to benefit from the estate of their deceased parent or parents, in the face of those parents leaving their children little or nothing in their will. Now, whilst this case was in some ways unusual, it nevertheless was not that unusual, and there are probably thousands of similar wills written which gain probate every year without being capable of challenge in the dramatic way that this will has been. The story is one of parents or the surviving parent falling out with one or more of their children, in this case one, and leaving their entire estate to normally charity, though sometimes to alternative beneficiaries such as godchildren. The case is not so much a post in the ground as regards the fundamental common law principle then embodied into the 1837 Wills Act and beyond, that an Englishman, and so consequently Irishmen, Canadians, Americans, etc., has the right to leave their estate to whomever they wish. It is not that, but it is a post in the ground in respect of the scope of the Inheritance, Provision for Family and Dependents Act of 1975, and what it is that can be expected of that act in this day and age. Now, first of all, let's just take a few lines from that act, which supplements the Wills Act in certain quite restricted situations. The act commences by saying where, after the commencement of this act, a person dies domiciled in England and Wales and is survived by any of the following persons, being the wife or husband of the deceased, and civil partners now as well, the former wife or former husband of the deceased who has not remarried, C, a child of the deceased, and D, any person who, in the case of any marriage to which the deceased was at any time a party, was treated by the deceased as a child of the family in relation to that marriage. Quite a complicated mouthful, really. And finally, E, any person who immediately before the death of the deceased was being maintained, either wholly or partly, by the deceased. So any one of those A, B, C, D and E may apply to the court for an order under Section 2 of this Inheritance, Provision for Family and Dependents Act on the grounds that the disposition of the deceased's estate, effected by his will, or the law relating to intestacy or the combination of the two, is not such as to make reasonable financial provision for the applicant. So that is the act upon which Heather Ilott based her claim for some part of her mother's estate, her late mother's estate. Now, if this Ilott versus Jackson ruling and award made by the panel of 3 judges at the Court of Appeal is not overturned, meaning altered by a further appeal process, then there are at least 3 consequential tracks that shall or could run from this event. The first is, for sure, that we shall all have to look at the way we deal as will writers with handling such instructions in the future, and perhaps to look again at some of those we've handled in the past. Then maybe there has now been an erosion, or a further erosion, of the principle of freedom of disposition. Though again, we do repeat that freedom of disposition has already been eroded by the very existence of the Inheritance Provision for Family Independence Act of 1975, though this ruling does form a new post in the ground as regards that act, as regards quantum, the amount of the claim, the successful claim awarded. And then thirdly, and in particular for the ears of those of our members who are qualified or are in the process of becoming qualified to advise people from the British Isles who own property in the EU, following the introduction beginning in 2012 of the Brussels IV doctrine, then for those people, they will want to consider the impact of this award seen through the eyes of probate courts and notaries in other countries in the EU, who will, from the 17th of August onward, be dealing with probate on behalf of expats from the British Isles, now living somewhere in Europe habitually, who have died, and who had written a will under the terms of Brussels IV, meaning a will written under the legal system of the country whose property they own is in, but where there has been a flick switch selection, either to have the will written under the law of that country, so an expat living for several years in Spain, preferably only with property in Spain and not elsewhere, now has the option to write a Brussels IV will under the Spanish regime in front of a notary, notarized, as if and in accordance with the laws of Spain, as if it were written by a Spaniard in strict accordance with the laws of Spain, who do not have freedom of disposition, or, in the alternative, in accordance with the law of the British Isles country that is his nationality, his country of nationality, which of course does have, still to this day, does have freedom of disposition written into its Wills Act. So there is now a flick switch, and that means that in the future there will be judges in Spain and France and Portugal and Cyprus granting probate, to use our terminology, in respect of expats who have died, where they have wanted not to give their property to their children, but to give it, for example, to their wife on first death, and then on second death to their children. Or, as in this case, where they have fallen out with their children, wanting to give their estate to charity. Now, what is quite different in this regard, when those judges look across from Spain to England and the way that this particular award has bounced, is that there is a significant difference where it is impossible for a national of a country, a citizen of Spain, for example, or France or Portugal, to write and notarize a will that does not include provision for the children of the testator, as opposed to what is quite different, where the children of the testator have rights under an Act of Parliament to challenge a will that fails to make adequate provision for them in their eyes. Nevertheless, this particular award, in which 1/3 of the entire estate has been given to the claimant, despite her being disinherited by the original will, and despite her not being dependent upon the testator in any way, as set out in the small section of the Act I've just read, could be capable of changing the mindset of a judge in an EU country looking at the inheritance position of a national in the UK. So, whilst deciding, for example, upon a challenge to a grant of probate or a grant of succession following a Brussels 4 will from someone who is living in Spain in respect of an expat from the British Isles, where that expat elected to make a testament written in Spain or France, etc., leaving their entire estate to people other than their children, and in particular leaving it to charity as a consequence of a family rift, then this decision of the 27th of July 2015 in the appeal court could play a role in inflating the view from abroad that British Isles is also moving towards forced inheritance of the kind that applies in almost every Napoleonic Code country. You see, the concept of a parent not leaving a substantial amount of their estate to or between their children is so alien to a judge in France or Spain or Italy or Portugal that they may well be tempted to regard this ruling as being a new norm in the British Isles, to the England and Wales part of the British Isles it applies to, and therefore that the children of any testator from the British Isles are pretty much entitled to 1/3 of an estate, whether they are left out of the Brussels 4 will or not that is before them. So there is a potentially dangerous slide to ruminate about, especially if you are involved or planning to be involved in writing wills for English-speaking people who own property in the EU. And that then raises a question, which is, might it then be that a Brussels 4 will offers a better solution to expats seeking to disinherit their children? You see, from the 17th of August 2015, an expat living in France, Spain, etc., intending to die there and having lived there for a fair while so as to be capable of being said to be habitually resident there, has this option to do what they have always been able to do, which is to write a pure local, say, Spanish will, in which they then have to adopt the rules of that country, which in the case of Spain is 1/3 can go anywhere, but 2/3 must go to your children. Or they could write a British Isles will, preferably split in two, one half covering their British Isles estate and the other covering their estate in Spain, in which they can observe all of the normal laws of the British Isles, having complete freedom of disposition if they wish to leave their estate on the 230 at Doncaster. Or they now have this third option, the Brussels 4 will, which I described briefly to you earlier, which has a flick switch. Just for good order, if they do take the Brussels 4 option, number one, they do have to be living out in Spain or France. Number two, they do have to be habitually living out there for some period of time, and no one quite yet knows what that period of time is, let's say 2 or 3 years. And number three, that will apply to the whole of their estate. And there are some challenges, because neither Ireland nor the United Kingdom, nor Denmark for that matter, have signed up to Brussels 4. Then there are some challenges as regards people from the British Isles writing Brussels 4 wills. And one of those challenges is that if they opt to write their Brussels 4 will as if they were an Englishman, able to give their entire estate to their spouse or to their partner, as is as equally often the case, who is a legal stranger they're not married to but they've lived together for 20 years, then if there is any estate remaining in the British Isles, whilst the Brussels 4 will work for them in Spain, enabling the deceased to give his or her half of the house to their partner, despite that being completely against the local law. So the Brussels 4 will work there. No one can yet see how, if there happens to be a pension pot remaining in the UK and a bank account with some savings, let alone another house or anything as complicated as that, no one can yet see how the Brussels 4 probate is going to reach back to the UK or the British Isles to deal with those assets, because Brussels 4 is not recognised by any of the British Isles countries. So there are some challenges to be faced, and that is why the Willwriters Association offers a complete course, a 20 lecture course in handling Brussels 4 clients, post-Brussels 4 clients, and by that we mean people who live in the British Isles but own property in Spain, who are currently working in Spain or France or wherever but intending to return to the British Isles but who accidentally die there, or finally who have moved to Spain intending to live out their lives there. Those three groups of people all have completely different situations, and they require exact but completely different advice as to how to deal with their situation in each of those three scenarios. So, the position of expats from the British Isles owning property only in an EU country and being habitually resident there is that, on first death, they would want the property to go to their partner or surviving spouse in the English tradition or the Irish tradition, and not to their children, pretty much under any circumstances. And then, on second death, for that property to be either divided between the children, or perhaps between some of the children because there's a black sheep in the family, or something else. Now, where there's a rift in the family, that something else might well be to their parents, or a sibling, or, as in this case, to a charity. So, as I've said, when a Brussels 4 will is written, the testator elects whether their wishes under the will should be governed by the law of the country where the property is, Spain, France, etc., and where the Brussels 4 will is written, or their homeland law. There will therefore be expats who will see Brussels 4 as an opportunity to write a will that is notarized in, say, Spain, and therefore convenient from the point of view of probate, because probate obtained in the United Kingdom has to go along quite a lengthy and potentially expensive journey to reach Spain, though that outcome is certain once it does, but leaving everything to one or more British Isles charities. So they see the advantage of writing a Brussels 4 will, having the advantage of local probate, not needing to draw anybody in to the matter from the British Isles, notwithstanding that they would be leaving money to a British charity or a British Isles charity, or any charity for that matter. Now, it will be a notary in Spain who will be required to declare that Brussels 4 will valid, or otherwise, under British law, as well as them being qualifying within the rules of the Brussels 4, which is habitual residence and applying to the whole of their worldwide estate, on the basis of the British Wills Act. And therefore a Brussels 4 will written in these terms is likely to be successful, with all of the money passing to the charity, because all of the British Isles Wills Acts give complete freedom of disposition other than for Scotland. So we'll put Scotland to one side in this conversation. Theirs is a sort of hybrid, somewhere between France and England and Wales will. That freedom of disposition can only be challenged under the Inheritance Provision for Family Independence Act of 1975, in what are really quite tight circumstances. And it could well be, or it could well turn out to be, that either strictly Brussels 4 does not empower or require the Spanish notary or court to take on board peripheral acts, but simply to refer to the Central Wills Act, or that even if that might be interpreted as being the intention that in practical terms a local Spanish court just aren't going to try to become an English or an Irish court. So as we speak today, no one yet knows how far EU countries are expected to go or will be prepared to go in putting on the clothes of British Isles courts to deal with subsequent legislation following on from the Wills Act itself in respect of subsequent claims after they have awarded probate, such as in the case we're talking about. So at the present moment, it's not easy to see how the children of a testator, an expat testator who's left everything to charity, could even begin to make a claim in Spain in the way that Heather Ilott has. That claim would have to be under the terms of the Inheritance Provision for Family Independence Act 1975, which on the face of it is completely meaningless in Spain or anywhere else, unless some form of bridge is built specifically for that purpose. It's only in those circumstances of Spain being prepared to consider a claim against the estate on that basis that the view declared in our previous comment concerning the likely inclinations and prejudices of Spanish judges might become relevant. And so, whilst the general risks associated with Brussels 4, especially where there is property remaining in the British Isles, influences the Willwriters Association to recommend that it is avoided by expats in favour of twin parallel British Isles wills written by a British Isles willwriter and member of this association. At the time of writing this lecture on the 30th of July 2015, it would seem that the Brussels 4 will, in that narrow situation, offers more of a safe haven for those families who are 1. British Isles expats, 2. habitually resident in any EU country other than the UK, Ireland or Denmark, 3. with children, 4. seeking to disinherit a child or their children, and 5. electing to do this by way of a Brussels 4 will based on their homeland British Isles law, because a Brussels 4 testament that leaves the entire estate to someone other than the children or that child is entirely lawful under the UK Wills Act, which is on the face of it Brussels 4's only requirement of Spain, France, Portugal, etc. And there is yet no provision for other legislation from the homeland country to be taken into account, though that might change on a case-by-case basis once the 17th of August has flown by. Let's just now forget Brussels 4 and return simply and strictly to the chronology of the appeal court award. Mrs. Jackson made her last will in 2002, which is a couple of years before her death in 2004, and in exactly the manner in which we prescribe it in our training, she wrote a letter to explain why she had disinherited her daughter to sit alongside the will in which her daughter was not mentioned, referring to the fact that her daughter had walked out of her home as a teenager to live with her boyfriend, and that breach had never been repaired. Mrs. Jackson then died aged 70 in 2004 and left her entire estate divided between the RSPCA, the RSPB and the Blue Cross Animal Welfare Charity. Her daughter from Great Mundon in Ware challenged the will and sought reasonable provision from her mother's estate under the terms of the Inheritance Provision for Family Independence Act 1975. Now, though she was a child of the deceased, she was not in any way reliant upon her mother, nor had been at any point in her adult life. However, the application was made and heard, seeking reasonable financial provision, and in this case, returning to the wording of the Act, reasonable financial provision is A, in the case of an application by the husband or the wife of the deceased, which is not applicable here, means such financial provision as would be reasonable in all circumstances of the case for a husband or wife to receive, whether or not that provision is required for his or her maintenance. That's nothing to do with this case, but it's interesting to remind ourselves of the wording. It has nothing to do with how much you're needing to live on. If you are a husband or wife, or an ex-husband or wife who has not remarried, then reasonable financial provision is just that. It's not linked to how much it costs you to live your life, or it costs the claimant to live their life. But B says as follows: in the case of any other application made by virtue of subsection 1 above, it means such financial provision as it would be reasonable in all of the circumstances of the case for the applicant to receive for his, which also includes her, maintenance. And yet the Wills Act says that there is no need for anyone to make any provision to anyone for their maintenance. So in 2010, Mrs. Ilott, who is an only child, won the right to an inheritance of £50,000 after a district judge concluded that she had been unreasonably excluded by her mum, Mrs. Jackson. So her first application was a success, and a district judge granted her £50,000. Mrs. Ilott appealed to have that amount increased, and so the matter moved to the High Court in London, where Mrs. Justice Parker dismissed the appeal in March 2014, ruling that the previous decision of £50,000 awarded was appropriate and could not said to be wrong. Mrs. Ilott is clearly a determined lady, and she took the matter once again to appeal. And that appeal was overturned by the High Court Judge, Mrs. Justice Elena King, who actually ruled that she should get nothing. Don't pass go, don't collect 200. So let's just recap on that. Mrs. Ilott went to her local county court with an application under the Provisions Act and was granted £50,000 out of a £500,000 estate on the basis that she had been unreasonably excluded. She appealed to have the amount increased, and Mrs. Justice Parker at the High Court in London dismissed the appeal, saying that £50,000 was perfectly appropriate and could not be said to be wrong. Mrs. Ilott appealed yet again, and a High Court judge, Mrs. Justice Eleanor King, overruled those two previous judges and said she can have nothing. Mrs. Ilott then took the matter in July 2015 to the next Court of Appeal, the three judges, and they have gone back to the original decision that she is entitled to an award, but have increased the award from £50,000 to 1/3 of the entire estate, £164,000. And now there is yet another potential for an appeal, although this time it will not be by her, it will be by the solicitors acting for the charity and anyone else who feels they should become involved at this point in time, financially perhaps, as to whether that award and judgment are correct. So it is a case of watch this space, but in the meantime we have set out our three proposals or suggestions to you as a will writer to check over what it is you do in these types of situations, to look back at clients that you have written wills for in similar circumstances, and to consider the situation through the eyes of a judge in Spain handling probate for future expats dying, having written a Brussels 4 will because they live in Spain, same applies France, Belgium, Germany, everywhere. So finally, let's just finish off with looking at some opinions voiced during the train of this action. The claimant's barrister, John Collins, claimed the decision to disinherit her was not due to the support of charities, but simply out of spite. And if that was taken on board by the judges, then it would mean a slight change in the way that we ask clients to write letters, setting out their reason for disinheritance, and to learn something from that comment. It has been suggested that the testator had no link to any of these animal charities, but was simply intending to spite her daughter by giving the money to anyone. She might just as easily have given it to any charities at all. Mr. Justice Black emphasised her extremely modest circumstances, that is, the circumstances of the daughter, noting she's still caring for her youngest child and has not worked for 25 years. And one might say there that the best advice that could have been given to the testator was to leave her daughter £10,000 or £20,000, which is always our first port of call. Disappointingly, a great many families, people, husband and wives, mums and dads in this situation are absolutely adamant that their sons, daughters or whoever should not see a penny from their estate. Nevertheless, common sense says that it is a good idea to put some award in. In this particular case, the claimant relies almost entirely on benefits and lives in a housing association home, and her husband had to give up his work as a delivery driver because of back problems and only works from time to time. So in a way the drift was that this family needed the money more than the charity, the animal charities, and in fact that was specifically stated. Mr. Justice Black, sitting with the president of the family division, Sir Nicholas Wall, and Lady Justice Arden, also said it had been unreasonable to cut her out. And so there is this issue of reason, and one part of that reason had to do with the fact that her father, the testator's husband, had actually died before she was born. He died in an industrial action before she was born, and the mother therefore included all of her prejudices, bitterness into her will, without any regard, as might normally have been the case, of her husband's views, who undoubtedly would have had a different view about his daughter, his only daughter, had he ever known her, had he ever been included in this conversation. And it was largely his money that the testator was giving away, if you like, on second death. The charities, the RSPC, the RSPV and the Blue Cross Animal Welfare Organisation, well, they warned that the case could have a major impact on future donations if it was felt that giving to charity rather than, for example, giving to your godchildren would be overturned more readily just because the charity had money in the bank and did not need the money as much as, in this case, the life and poverty of the daughter who had left back. The solicitors, James Aspden from Wilson Solicitors, was reported as saying this is not a case where the late Mrs. Jackson in some way failed to care for and bring up her child. On the contrary, she gave her daughter an excellent upbringing until Heather opted for independence and left home. Mrs. Jackson left a clear explanation of the reasons why she had chosen not to leave her estate to Heather, with a written request to her executors to defend any claim Heather might bring. However, in the latest hearing, Lady Justice Arden said that Mrs. Islott's mother had been unreasonable, capricious and harsh, and ruled that she should therefore receive a greater proportion of the estate. And so back to those three things to be taken from this newsletter. We all have to look again at the way we deal as will writers with handling such instructions. There has been, one must say, an erosion of the principle of freedom of disposition, albeit that freedom has already been eroded by the Inheritance Act of 1975. This does form a new post in the ground as regards that act, as regards qualification and quantum, the amount the country could expect to receive from the estate. which has now been pushed right up from a typical 10% to a very untypical 30%. And then for those with thoughts for clients of theirs that own property abroad, or interested in that marketplace of clients who own property abroad from the British Isles, own property in the EU, then into the eyes of an outsider, particularly of a country in the Napoleonic Code countries who have forced inheritance rules to give to your children as much as 2/3 of the estate, in fact in the case of intestacy the whole estate. This award edges the UK closer to those Napoleonic Code nations where children, though not necessarily eligible to the 1905 Act, actually is broader than in this case where children have a legal right to decide part of their estate. And that might offer an advantage, but it might offer a complete disadvantage to people from the British Isles who are habitually resident in an EU country and who want to write a will in those terms. So what we ask you, or suggest that you do next, is 1. You might like to take the WA, the Willwriters Association retraining video, which is just in the process of being buffed up in the light of this decision, which is a video course upon disinheritance and the 1975 Act. And secondly, you might like to think about contacting all of your past clients who have ever instructed you in these terms, leaving even a single person out of the will, who has ever left anyone out of their will, proposing a review of the will in the light of the ruling, and if you take the course, what we tell you and conclude in that course. And if we have whetted your appetite and not sent you to sleep on the subject of people from the British Isles who own property abroad, whose wills are about to be globally made invalid, all of the wills written, virtually every will written for anyone who owns property abroad, is under threat of being made invalid by the introduction on the 17th of August 2015 of the Brussels 4 legislation throughout all 28 EU countries other than Denmark, the United Kingdom and Britain. If this has whetted your appetite, then you should click the link on this page, newsletter page, and look at the course you can take, Willwriters Association course that you can take to become absolutely expert in that field, and virtually unique because hardly anyone seems to be able to make head or tail, other than a few very specialised lawyers and barristers who charge very specialised fees, make head or tail of what is going on with wills in Europe. And yet there are 1.5 million exiles from the British Isles, expats living, who anticipate they will die in Europe, and there are over 1 million families in the British Isles who own property abroad as holiday homes or investments in the EU, and who have written and now require to reconsider a will disposing of that property on their death. Well, thank you for your time in listening to this video version of the August newsletter. We look forward to seeing you on the next occasion. Good day.